Hello and welcome to this lecture on Roman law. My name is Elizabeth Drummond and I'm really happy to join you today to talk about wrongs in Roman law, which is a topic we cover in the Roman Introduction to Private Law course in the first year in Oxford. I'll try to give you an idea of some Roman law wrongs and how we study them, sources, the sorts of questions we ask and try to answer, relevance to modern law and so on. Let's begin by going to the Roman starting point. It's the actions that can be taken in court. This is the sharp end of the law. Before the judge, one person wins, the other person loses. If we're thinking about taking an action for a wrong, then we're looking at an action which says that the defendant should pay for what they did. The claimant says perhaps that the defendant let their cart get out of control and that the claimant's horse was run down and killed. It was a valuable horse, the claimant wants compensation for the loss of their horse. Or perhaps the claimant says that the defendant stole their horse. As well as getting their horse back, they want the defendant to pay a penalty for doing wrong by stealing it. An action for a legal wrong says that the defendant, that's B here, has done something wrong in relation to A. There's been some sort of interaction between A and B, and A is suing B on the basis that B did something wrong. In the theft example, A says that B stole their horse. If A is successful in that, then B will have to pay a money penalty for the theft. In the beginning, to know Roman law was to know a list of actions, claims that could be made in court. And you can see how this led the Roman lawyers to focus on which interactions will ground an action between A and B. If the action's for theft, what fact situations will fall within that action and which ones won't? What does it mean to say that B has stolen from A? Other interesting questions can be asked about what happens if A succeeds in their action against B. What should their remedy be? I've already said that in the theft example, B has to pay a money penalty if A is successful in showing that B did steal their horse. That's not the remedy that Roman law imposed in relation to all civil law wrongs, and we can ask why. Technically speaking, this flowchart actually has a step missing. If an interaction between A and B entitles A to bring an action, then we can say that it has immediately generated a legal obligation owed by B to A, which will be enforced by the action. Even before the action comes to court, B's conduct towards A has legal consequences. It was wrong. It created an obligation. The action is just the enforcement of that obligation. The remedy discharges it. If we take a step back, we can see that this is all about defining rights and wrongs in the law. From a legal point of view, it's about distinguishing between what you have a right to do, if you like, and what the law says it is wrong to do. Some things are morally wrong, but not legally wrong. Some things are generally accepted as needing to be legally wrong, like stealing or hitting people, but we still need to define the boundaries. We might say that there are cases where it's okay to hit someone. For example, if they're your opponent in a boxing match. In relation to theft, we need to think about cases other than the classic case of grabbing someone else's stuff and running. For example, if John lends me a book and I decide that I like it so much that I'm never going to give it back, is that theft? And if so, how should we define theft in order to catch that situation? These are the sorts of questions that lawyers need to answer in order to define legal wrongs, to differentiate between legally acceptable conduct and wrongful conduct. In Roman law, we find a lot of discussion about how and why these distinctions were drawn, of the kinds of conduct which were wrongful, how the various legal wrongs were defined, and what the remedies were. So how do we know about what Roman law said on these matters? There are a couple of points to keep in mind when studying Roman law. The first is that Roman law changed a great deal over time. The first milestone for Roman law is generally said to be the 12 Tables. This is the name for a statute which is said to have been carved into 12 bronze tablets, hence 12 tables. That was passed back in around 450 BC. And in the first year course we go all the way up to the reign of Justinian in the mid-6th century AD. That's about 1,000 years. Many things changed in Roman law over that time. The other point we need to keep in mind is that we have various sources to know what Roman law actually was at different periods, and they attach to various different points in that timeline. The reason why we focus on Justinian's reign is that he masterminded a huge codification of Roman law. I've put that in quotes because it wasn't a law code in the modern sense. What it aimed to do was to compress all of the Roman law in force into 3 books, so it was more like what one of the Oxford professors once called a pocket law library. The first book in the library was the Codex, which was a collection of laws declared by emperors. So we can anchor our timeline by putting in Augustus, who took power at the end of the Republic and started the line of Roman emperors. The second book is the Digest. This is a collection of legal writings from what we call the classical period of Roman law, which again fits in the middle of our 1,000-year period. The Digest gives us some insight into how Roman law was developing over that classical period, running from the end of the period before Augustus's reign up to the 50 years of chaos which ended the 3rd century AD and ushered in what we call the dominant period of the Roman Empire. We cannot perfectly reconstruct the legal development of that period. The point of the Digest was to use the classical writings to state the law of the 6th century. So where the classical writings stated older law, they were edited and changed to update it, and the original writings were lost. However, this editing work was not done very thoroughly, it was rushed. And we can study Justinian's library like archaeologists, trying to work out what the original text looked like and what edits were made, and so what the previous law was and how it developed into the 6th century. The third book in Justinian's codification is the Institutes. The name Institutes comes from a Latin word meaning to teach, so it's a collection of teachings. In this instance, a collection of teachings for first-year law students, so a short statement of the private law intended as a starting textbook for the students who were about to embark on Justinian's new revised law course studying his library. The Institutes were based on an earlier book from the classical period. This book is also called the Institutes of Gaius, a law teacher from the 2nd century AD who also wrote a book intended for first-year law students which would help them get into the basics of Roman law. We have a virtually complete manuscript of that book in its original text. On this slide, I've highlighted the 2 institutes because those are the books we use as set texts on the Roman law course in the first year. They are set in English, there is no reading in Latin. What you'll notice is the long period which passed between Gaius writing his institutes and Justinian's team compiling theirs, almost 4 centuries. Lots of scope for legal change in that period. Let's now look at the major Roman legal wrongs which we study in the Roman law course. We'll start with what Gaius says. He picks out 4, or really 3 wrongs that he's going to discuss in detail in the book. There were others, but these were the big 3, so let's focus on them. The first one is theft and also robbery. The remedy for these is a penalty for the wrong. It's usually 2 times or 4 times the value of the stolen item. The victim can claim for the property back on top of that. The second one is the wrongful infliction of loss, typically loss by damage to property. And the remedy for that is generally compensatory. There are sometimes penal elements to it, but in general it's about compensating the victim for the loss they've suffered by their property being damaged. And the third one is translated here as committed an outrage. This is the Roman delict of injuria, which broadly translated means insult. For example, it might be a slap to the face, a punch to the nose. It also expanded to include things like sexual harassment. The remedy for that is solace for the outrage suffered. That is a monetary payment that isn't really a penalty, it isn't really compensation. It's just an amount to be paid for the outrage that's been caused by the insult being committed against the victim. We can arrange those 3 private law wrongs in 2 categories like this. On the left-hand side you have the wrongs against property, the economic wrongs. Theft, robbery, the wrongful infliction of loss by damage to property. On the other side, we have the wrongs against personality, which is a non-economic interest. Injuria, the wrong that centres on outrage and insult, isn't focused on economic interests. It's focused on hurt to the personality. So examples of injuria, as I was saying before, they include physical assault, verbal insult, an insulting poem, for example, sexual harassment, bringing someone's character into dispute in other ways. There are lots of examples discussed in the text. For example, falsely advertising an auction sale of the victim's belongings. That makes it look as though the victim owes money that they can't pay. Injuria in the text is generally not defined as such. It's explained by use of all of these examples, but we can bring it all together to say that it's a general principle covering situations in which one person wrongfully attacks the personality of another. Injuria is the wrong that you suffer if someone pushes in front of you in a queue. They assume that their interest in getting to the front more quickly can be prioritised over yours, and so they belittle you in order to improve their own position. But in fact there's no such entitlement, and they've trespassed on your right to respect. I think many students find Roman law surprisingly sophisticated on this point. In 161 AD, Gaius is already able to describe a principle which recognises wrongs against personality, this non-economic interest. And the fact that it's a non-economic interest brings up the point I was noting before. It gives you a problem in assessing damages because there's no particular economic loss. The action for inuria said that given the defendant had done such and such, for example, punched the claimant on the nose, the judge needed to award whatever amount of money was fair and just for that assault. Inuria is a great example to use to show you about how we study the development of Roman law over time. So you've seen the next slide before. This is the milestones of Roman law in terms of our sources. So we know from what Gaius's institutes tell us that already by 161 AD, inuria had that flexible, wide scope which focused on the personality. But 6 centuries earlier, when the 12 Tables statute was published, inuria had a far narrower scope. The 12 Tables statute mentioned inuria, and this is what it said. What we have here is a table with the event on the left-hand side and the consequences on the right-hand side, the remedy. Translating the Latin words here is not always straightforward, but os fractum in the middle there means a broken bone, and a possible translation from membrum ruptum is an injured limb, perhaps a severely injured limb. So it seems that all of this goes from worse to less severe. So retaliation seems to be for the worst injuries, where you're entitled to go and retaliate by inflicting the same injury on the person who did it to you, an eye for an eye, a tooth for a tooth. But for a broken bone, the penalty is 300 copper coins, so it's in money. And then inuria. What the 12 Tables seem to be saying is that if someone does inuria to you, then it's 25 copper coins. So if we follow the track and assume that as it's lined up with the other two it must have something to do with physical injury, then we can come to the view that inuria in the 12 Tables was about less severe physical injuries, maybe a cut or a beating that inflicted bruising, something like that. If that's right, then having reconstructed it from the 12 Tables, we can put it up against Gaius's institutes in the 2nd century AD, and that contrast is likely to bring up a lot of interesting questions. At this point, I'll try to answer some of the questions that typically come up when I give this lecture in person. So one question is, how did the Romans go from a fixed penalty of 25 copper coins to the case-by-case assessment that I talked about earlier on? What happened was the Romans changed the action for inuria so that it told the judge to assess what the inuria was worth, not just to award 25 copper coins for everything. That was done sometime back in the time between the 12 Tables and Gaius, probably around the 3rd or 2nd century BC. It was partly because of inflation, which had made 25 copper coins a nominal sum of money which wasn't a deterrent to a wrong, and partly because with a lot more conduct coming under inuria, it didn't make sense just to award a fixed sum for everything. That links into another question that I'm often asked, which is how did an action for a minor physical injury turn into one for any wrongful trespass on someone else's rights or dignity, with all those examples that I talked about before? The change in the remedy focuses attention on the real problem with a slap or a punch, and that is that it's a trespass to the person. It's a way of expressing that the perpetrator feels entitled to put themselves above their victim by trespassing on that person's bodily security. If someone slaps me to get me to stop talking, or shoves me out of the way of a queue, or if they're just in a hurry, the bruise doesn't really matter as much as the humiliation. This person's treated me as though I'm worth less than them. And if they do it in front of an audience, that's even worse. Now other people may feel entitled to ride roughshod over me as well. That sort of hubristic disregard for another person's personality can be expressed in other sorts of conduct too. And other actions were added, for example, the action against someone who brings the victim into disrepute in some way, special action for sexual harassment, and so on. And those are all later on brought together because it's recognised that they all deal with the same idea: trespass on dignity, arrogance on the part of the defendant pushing the victim down, and it all gets synthesised into the one delict of inuria. Another question people sometimes ask me is, why don't I seem sure about the 12 tables interpretation? This is definitely something we discuss in tutorials. There are different ways to interpret what the 12 tables said on this. It may be that inuria in the 12 tables didn't mean minor physical injury at all. Maybe it meant something else. That would give us a different view of how the law developed after the 12 tables. People also sometimes ask me whether the Romans just sued each other for inuria all the time because it seemed really wide. That's a good point. We do know that there were a few things keeping it under control. The inuria had to be wrongful, so it couldn't be accidental, it would typically be intentional. It also had to be against the standards of acceptable conduct in Roman society at the time. So, for example, it was okay in Roman times to go outside your debtor's house and shout, "Pay up what you owe," in order to get them to pay your debt. That didn't count as inuria, even though the debtor would be embarrassed and hurt about having all their neighbours told about the debt. There was also a limitation period. The action for inuria had to be brought within a year, and there was some sort of mechanism whereby if you had forgiven an insult, you couldn't later bring an action on it, though we are not clear on how that worked. Finally, is inuria like anything in modern law? That is also a really good point that we would discuss in tutorials. In that discussion, we might draw comparisons with modern statutes on things like sexual harassment and equality law, even on human rights. But we'd note in all of that that while nowadays we think of people as having equal rights, inuria in Roman law was very much a product of society at the time, and it recognised that people were of varying social status. Some people were entitled to more respect, others to much less. A senator who was insulted by someone of low social status would get more damages for an insult than someone of low social status if they were able to sue at all. So that's a taste of inuria and a contrast with the economic wrongs. There are many things I could say about theft and robbery and about the wrongful infliction of loss. In tutorials on those delicts, we discuss things like how the Romans defined theft, how and why that definition changed over time, the distinctions they drew within theft and between theft and robbery. We talk about the delict of wrongfully inflicting loss and how that expanded from a statute originally passed in the 3rd century BC. The Romans interpreted the words in that statute to cover only situations where economic loss was caused by direct injury to property. We talk about that interpretation, what the Romans did about other situations of economic loss, for example by indirect injury to property, and what that meant. We discuss things like what the Romans meant by wrongfully, and what the texts show about the Romans' decisions on when a defendant ought to be found to be at fault for a loss, and liable to compensate the claimant for it. But my time here is up. I do have some suggestions on this slide for further reading, and of course you can consult the Law Faculty's website for more information about the Roman law courses at Oxford. I think it only remains for me to say that it has been a real pleasure for me to talk to you today. Thank you.